Hey everyone, I'm John Hansen. I'm a lawyer, I'm a lawmaker, and in this video we're going to talk about Constitutional Amendment G. Amendment G is a proposed constitutional amendment that is set to appear on your November election ballot, and if it's passed, written into our state constitution will be abortion through all 9 months of pregnancy, even up to the point of birth. It would take away parents' rights to know if their minor daughter is undergoing an abortion procedure, and it even eliminates basic health and safety standards, protections for mothers. And so in this video, we're going to talk through the language so that you can better understand exactly what they're trying to write into our state constitution. Amendment G is written in 3 paragraphs, actually 3 sentences, and each of those sentences reflect 1 trimester of pregnancy. The proponents of Amendment G like to say that this would just go back to how it was before Roe versus Wade was overturned by the Supreme Court, but that's not true. In fact, this trimester framework was thrown out by the Supreme Court, a moderate Supreme Court, in the early 90s as unworkable and not constitutional. But Amendment G is written into 3 sentences, so let's go through those 3 sentences together. The first sentence says, before the end of the first trimester, the state may not regulate a pregnant woman's abortion decision and its effectuation, which must be left to the judgment of the pregnant woman. Now, it's really important to know that none of these terms are defined in Amendment G. And in other amendments, in other areas of the law, you'll see where there's a confusing or vague term, those terms will have definitions so people can know exactly what they're passing. Amendment G doesn't have those definitions. And so when we look back at that language and that term effectuation, where it says the state may not regulate a pregnant woman's abortion decision and its effectuation. Well, what does that term effectuation mean? It's not defined in Amendment G, and so we have to just go to the general dictionary definition of effectuation, which means to bring about. So when you plug that definition into the language of Amendment G, what you have is that it says the state may not regulate the bringing about of the abortion decision. So it's a blanket prohibition on any regulations relative to abortion whatsoever in the first trimester, which is when most abortions occur. So what does that look like in practice? Well, that means parents' rights to know that their minor daughter is undergoing an abortion procedure, that right is taken away by Amendment G. This would be the first time that a right of parents is actually removed by a constitutional amendment. But that's what we have with Amendment G. And remember too, this is a constitutional amendment. And so what that means is when you have a constitutional amendment, that's going to override all of our states' statutes when they conflict with each other. And so when you take parental rights, for example, we've had parental rights in this state for decades so that parents can know when their minor daughter is undergoing an abortion procedure. But because of the way Amendment G is written, it would override, it would take away, it would cancel those parents' rights. Even basic health and safety standards for mothers are removed, canceled by Amendment G because of that broad language. Think protections to make sure that an abortion is done by a doctor in a licensed and inspected facility. Even those basic bipartisan common sense protections for women are overridden by Amendment G. And so if you look at the issue of abortion and you want to protect women's health, Amendment G takes us in the wrong direction. It takes us backwards because it bans the state from enacting health care protections for mothers and instead sets the stage for unregulated wild, wild west style abortions. In the second trimester, the language says, after the end of the first trimester and until the end of the second trimester, the state may regulate the pregnant woman's abortion decision and its effectuation only in ways that are reasonably related to the physical health of the pregnant woman. And so now, the only regulations allowable in the second trimester are those related to the physical health of the pregnant woman. So 2 things to note about this. First of all, in the latter portion of the second trimester, that's when babies are viable outside the womb. Most people don't agree that after the point of viability, when the baby can just be born and survive outside the womb, abortion shouldn't be legal during those later term abortions. But right here, already in the second trimester, Amendment G legalizes late term abortions, and there's no regulations, no protections that can be placed in our laws to protect unborn life from late-term abortion. Not only that, notice how it's only in the second trimester that we can finally start to enact protections for the physical health of mothers. And so what that says is then, even back in the first trimester, it becomes even more clear that no protections for the physical health of women are allowable in the first trimester. It's only in the second trimester that you can start to enact physical health protections for women. That's too extreme. That's poor drafting. That's dangerous language, and we should not write that into our South Dakota Constitution. Once that's written into our South Dakota Constitution, it's not something where the legislature can just go in and amend that, or the governor can go in and fix that. If we prohibit the physical health protections for women in the first trimester of pregnancy, there's nothing we can do about that because it'll be written into our South Dakota Constitution. In the third trimester, the language says the following. After the end of the second trimester, the state may regulate or prohibit abortion. So now we see this is written differently than the first and second trimester. It says that the state can regulate or prohibit abortion, but there's a big exception. It says, except when the abortion is necessary in the medical judgment of the woman's physician to preserve the life or health of the pregnant woman. So let's read that one more time. It says, except when abortion is necessary in the medical judgment of the woman's physician to preserve the life or health of the pregnant woman. Very importantly, as you'll recall from earlier in this video, these terms are not defined. And so when you have an undefined health exception, it can lead to some real big problems. And let's talk about how that can be the case. First of all, remember in the second trimester, the language says physical health. The drafters wrote physical health. But in the third trimester, it doesn't just say physical health, it says health. And so the courts are going to interpret that to mean more than physical health. What could that mean? Well, that could also mean mental health. And in fact, when Roe versus Wade was decided by the U.S. Supreme Court, they decided a companion case called Doe versus Bolton. And in Doe versus Bolton, the Supreme Court actually defined, in their terms, an otherwise undefined health exception. And they said that an undefined health exception means all factors: physical, emotional, psychological, familial, and the woman's age. It is so incredibly broad without proper definition. But it's even more broad in the context of Amendment G because, again, remember, in Amendment G, it says to preserve the health, to preserve the mental health. And so when you look at this in the context of who actually decides under the language of Amendment G, which is the physician, well, who's the physician in the context of a late-term abortion? That would be most likely a Planned Parenthood abortionist. You're going to have a Planned Parenthood abortionist saying that an abortion is legal all the way up to the point of birth to preserve the mental health. It's not even under this language that there has to be an existing mental health problem, which we all know, there can be serious mental health problems when it comes to pregnancy, and we all understand that, and mothers need help when those situations arise. But that's not even what we're talking about here, because here we're talking about a Planned Parenthood abortionist who is seeking profit. They're driven by the profit motive to go and sell abortions. In this case, they can argue that an abortion is necessary to preserve the health of the mother. And so what we have in Amendment G, when you read it all together, is late-term abortion, not only just early abortion, but all the way through the 9th month of pregnancy. Most people do not agree with abortion late term all the way through the 9th month. It also takes away parents' rights to be involved in their minor daughters' decisions when it comes to abortion. Right now, under South Dakota law, parents have a right to know if their minor daughter is undergoing an abortion, but Amendment G takes that right away from parents. For the first time ever, their rights will be removed by an amendment to the Constitution. And it takes away those basic health and safety standards. We want mothers to be seen by competent doctors in safe facilities. But Amendment G takes us backwards. It takes those rights and protections away from mothers. And so Amendment G is too extreme, and we should reject it on the ballot in November. Thank you very much for watching.